Is adding an arbitration clause to your client contract beneficial for your wedding business? On today's podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hello out there. Welcome back to the program. Glad to have you back. Super appreciative of everyone out there listening, providing feedback, commenting on the YouTubes, hitting me up on Instagram. I really appreciate the feedback. It really helps, and it helps shape the trajectory of the content of the podcast. So again, would love it if you have a suggestion for content, please hit me up. You can shoot me an email, hit me up on Instagram, or leave a comment in YouTube. And also, if I may, please subscribe to the YouTube channel. I would love to get to 1,000 subscribers by November. That is kind of my goal, my bucket list, to get 1,000 YouTube subscribers by November. So if you can make that happen, I'll be forever grateful. So about today's topic. Often I hear from clients, well, Rob, should I add an arbitration clause to my contract? What is arbitration? What does that do? Is it good? Is it bad? This type of thing. So buckle up. Here we go. Is it good to have an arbitration clause in your contract? Maybe. I typically do not recommend them for wedding professionals. So let me just say that right at the outset. You can actually stop listening now. No, I'm just kidding. So arbitration is an alternative dispute resolution method. It is an alternative to litigating in a court of law. It's, 30 years old, 40 years old. It came about a generation, maybe two generations ago, because as you may already know, our court system is backed up. So we're like, okay, well, let's kind of fashion into the law the ability for parties to have an alternative to suing each other in court, and that's arbitration. So an arbitration proceeding is separate and apart from suing somebody in court. An arbitration is typically adjudicated by an arbitrator. That is a person or a panel of persons that's going to hear both sides of the story and render an arbitration award. Okay, so arbitration is an alternative dispute resolution method, an alternative to suing in court. And you essentially, it's kind of the same. You give the person a statement of the claim or a petition of some sort, and you are guided by the rules of arbitration. And the rules of arbitration are going to depend on what arbitration company that you use. And so at the end of the day, you will have your claims, or if you're a defendant, the claims will be heard against you in front of, theoretically, a neutral arbitrator who's going to be kind of like the judge. Okay. So, arbitration is kind of it's not uncommon at all. Like I said, even though it's a pretty recent phenomenon, it's everywhere. Your contract with your cell phone provider is probably arbitration. Your gym membership is probably arbitration. I guess an example of arbitration that you might have heard of in terms of like, have I ever seen something going on with arbitration? All of the shows on TV are arbitration. Judge Judy is an arbitration. That is, the parties have agreed that this lady, who is not a judge in the real sense of like this person is, in a court of law, this, in a state somewhere. Judge Judy is an arbitrator. She's hearing the parties. She's applying what she believes is the law to their matter and rendering an award. That's arbitration. It's outside of the public proceedings. So, getting back to like, okay, we understand what arbitration is. Should I invest in that? It seems pretty cool. I want to go in front of Judge Judy. Seems like a good time. Well, there is a reason why it's in your cell phone contract. It's in your gym membership. It's in your cable contract. Because arbitration has some positives that are good for certain industries or certain companies. And those companies are large conglomerates that have thousands of transactions every day. Okay. And the reason why they choose arbitration, okay, I'll spill the beans here. Number one is in the contract, you're required in your cable bill or your cable contract, whatever it is, you're being required, probably almost 100% certain, to arbitrate your claims with a particular company. And guess what? If you are issuing thousands of transactions a day and designating one arbitration company, in the long run, who do you think the arbitration company is going to favor over the long run? Probably the company that is employing the arbitrator. And that's not just a conspiracy theory. That is borne out by many statistics. Arbitration awards tend to favor the company that is the large company that is naming a particular arbitration company. So that's the first positive for arbitration if you're a giant multinational corporation, is that the awards are going to favor you because you're the one that's essentially assigning the work to the person. Second is that almost all arbitration proceedings, and I don't know any that are not, they're all private. So a typical lawsuit, you can go to the courthouse, and if you can get in early enough, you can sit in the front seat and watch everything unfold. You can go down to the clerk's office and pull up whatever has been filed in those cases. It's what we call a public proceeding. It's not in private. It's not secret. Arbitration is confidential from start to finish. You are not going to be able to, typically, you're not going to be able to get documents that have been filed on an arbitration matter. And you're certainly not going to be able to sit in the front row of anything. And you're certainly never going to know the outcome of an arbitration proceeding. It's all confidential. Okay? So that's another reason why these large companies want arbitration, is because they don't want the public to know what's going on. If John Doe in New York sues for whatever reason, Jane Doe in California won't know the result of that and can't use it to help her case, and vice versa. It's all private. Third thing is this, is that typically, but not always, this is not always the case anymore, is a selling point of arbitration is that sometimes it is faster. So from start to finish, it can be sometimes as soon as 90 days, 180 days. With the filing in a court of law, it could take years, depending. So I'll put small claims courts over another section, because that's something entirely different. At any rate, okay, it's a lot faster. Large companies, again, tend to want arbitration because sometimes it can be cheaper. So again, the large companies want arbitration because they agrees in the will. They're picking the arbitrator, and awards tend to favor the ones selecting the arbitrator. Okay. Second, it's typically faster. It can be cheaper, and it's private. Okay. Now you can ask yourself as a wedding professional, do any of those things matter to you? Typically, they do not. You don't care that somebody in another state can go look at a filing in a case that you're involved in. It's not going to matter to you that it's confidential. It's not going to matter to you that typically that it's, somebody can't find out about it. Okay. The reason why at the top of the show I say I don't recommend it for you is because for the typical wedding professional, I have found, this is anecdotal, I haven't conducted my own studies. It's not like I'm going to dusty courthouses and looking at files and, like it's a montage of me going state to state trying to research this. It's my anecdotal experience as an attorney for a decade, that when it comes to the service industry with wedding professionals, arbitration is not necessarily going to be cheaper. It is not necessarily going to be faster. And the reason why I say that is because if you file a case in your county small claims court, you can often get that started for less than $200 or $300. You can be in front of a judge, depending on what state you're in and depending on how, thick the docket is. You might be in front of a judge for a small claims hearing in 180 days, 6 months. Okay? Being out of pocket, only that filing fee. Okay? With arbitration in the same situation, you are going to have the filing fee. But then what happens is that you are going to be required to pay, typically, you're going to be required to pay the arbitrator. The arbitrator can be anywhere from $200 or $300 to $1,000 an hour, and that's split between the parties. Most often it's split between the parties. And so you're going to have to pay that arbitrator for everything that the arbitrator does in your case. And I would say that in a typical breach of contract case between a wedding vendor and a client, it's not going to be that much, but it could be. If there's a motion that is filed in arbitration and the judge needs to read it and render a ruling on it, that costs you a few $1,000s. In a regular court of law, you don't pay any of that. You're the time of the judge, the time of the judge's clerk is baked into the filing fee of what you pay when you file the lawsuit, right? So the arbitration sometimes, many times, is not cheaper than just going to a small claims court or even going to whatever your normal trial court is of your state, the entry trial court. So it's not necessarily cheaper. You're paying the arbitrator. You're also paying the filing fees. Second is that as I mentioned a little bit earlier, the rules of arbitration are going to depend on what company is rendering the arbitration proceeding. So there are many, many arbitration companies, and they all have their set of rules. And sometimes I feel like the navigating the rules of your local state court, your local small claims court, is easier than navigating the rules of a particular arbitration company. Okay. Sometimes you can go to the court, get help from a clerk, you can get help from the local library, these type of things. But, I in my experience, the help with arbitration rules is not as, available. So, not cheaper sometimes, a lot of times. The rules can be a little bit problematic. And in my experience, not all arbitration companies are equipped to handle injunctive relief. Injunctive relief is a concept in the law where you are asking a judge to make someone do something or stop doing something. Most of the time in the law, we are asking the judge for money. We are asking for compensation. A couple of episodes ago, or a few episodes ago, we talked about expectation damages in a breach of contract claim. Injunctive relief is going, judge, my neighbor's fence is encroaching on my yard. I want you to render an order that forces him to push it back 2 feet. Your Honor, I've signed a contract to buy the Mona Lisa, and I'm demanding that the person give me the Mona Lisa because I've already given them the money for it. Your Honor, I don't want individual A to be within 500 feet of me. The judge renders the order that says this person has to stay away from you or risk being in contempt or risk going in jail. That's injunctive relief, okay? Some arbitration companies are not equipped, and it's more difficult to get emergency injunctive relief from, in my experience. It would be much easier to go down to your state court and file the emergency motion for injunctive relief. And so, well, I'm a wedding professional, why would I need that? Some wedding professionals do need it. Some wedding professionals, maybe if the client is about to sell a photograph that you took commercially and you don't want that to happen, you want the judge to say, I am stopping you from making this transaction. Okay, that would be an example of injunctive relief that you would want the court to give, and would be made more difficult if there was an arbitration agreement in place. Okay, Some arbitration companies have handled this aspect of the law, but some still are lagging behind with how easy it is to get in front of an arbitrator who can render a order that is enforceable against somebody in an arbitration. So there are other examples I can give about why injunctive relief might be important to you as a wedding professional, but just keep this in mind that some arbitration companies, it's harder to get. And finally, there's another component where in some small claims courts, you as a wedding professional operating as a company, like an LLC or a corporation, are allowed to argue your own case without an attorney. Some small claims courts across the country allow you to do that. Okay? Most of the time you cannot. In the regular, not small claims court, but the regular trial courts, typically a corporation or an LLC must be represented by an attorney. That's just how the law works. People can be pro se, like if you're an individual, like you're a sole proprietor, this doesn't apply to you. But typically a company, an LLC, a corporation, must be represented by an attorney in most trial courts. In small claims courts, some small claim courts allow you as the owner of an LLC just to go in and represent yourself, kind of quote unquote pro se. Now, some arbitration companies that would arbitrate a matter have that rule as well, that an LLC must be represented by an attorney. An individual can be pro se, but a company must be represented by an attorney. Some arbitration companies require that, and some states require that as part of an arbitration proceeding. So that's something also to consider as well. It might be better for you if it's easy for you to file a breach of contract claim against a client by yourself and go to the local small claims court and pay $100, and then you go in front of the judge and present your evidence. Isn't that much easier than going through the process of arbitration, which you might require you to hire an attorney to get the end result that you want? So at the end of the day, I typically don't like arbitration agreements for those reasons, that it's typically not as cheap. It's not cheaper than filing a small claim, filing a claim in small claims court. It is, the rules can be problematic. The injunctive relief process can be kind of messed up. And then finally, there's the issue of whether or not you need to be represented by an attorney in the arbitration proceeding. So at the end of the day, talk to your local counsel, talk to an attorney. Hey, what state am I in terms of, is it good for me to get an arbitration agreement in here or not? Okay. So an arbitration agreement in your contract, may or may not be a good idea. I'm saying that I typically do not recommend them. Hopefully that kind of answers some questions. If you have more questions about arbitration agreements in your contract, shoot me an email, leave a comment on YouTube, like and subscribe to the podcast wherever you get it. That would be fantastic. Yeah, great. So with that, that's going to conclude this episode. So we will see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.